Welcome to Prediction News Update. I'm Chris Gerlacher, the senior political reporter for Prediction News and the industry analyst for Prediction News as well. We're covering some of the big stories coming out of the prediction market industry. And, Dan, we only talked 4 days ago, and there's still some brand new stuff to talk about. There's been some brand new developments that are going to be really exciting. I'm here with Dan Wallach, sports betting appellate lawyer. Dan, how you doing?
I'm doing really well, Chris. Thanks for having me back on 4 days later. The news cycle is just constant when it comes to the prediction markets lately. We could be doing prediction markets today, tomorrow, and tonight, like some of the NBC programming of years ago. But
Right.
we got a pretty full docket today.
Yeah, absolutely. So we're going to go through Maryland supplemental briefs. I want to go through Kalshi's request for a delay in the Third Circuit case. Kalshi is also one of the parties that's received lawsuits from 5 states. So we're going to dive into some of those. There have been talks about a FanDuel Kalshi partnership that's been reported and discussed, but it's been very light on details. We'll unpack some of that. And then I want to end with the amicus brief from the tribal gaming industry. That's going to be really important going forward.
We talked about that on the last episode. I think we predicted, we did a prediction market on an amicus curiae brief being filed by the Native American tribes in courts all over the country, and the start of it is going to be on Tuesday. So they're going to kick things off in the Third Circuit. We'll get to that shortly.
Yeah, that's going to be really exciting to watch. Before we get there, let's start with Maryland. What's been going on with the Maryland supplemental briefs?
Well, as many of you recall, when we did this last week, the Judge Adam Abelson asked for supplemental briefing directed to the issue of judicial estoppel and then any other issue that the parties wanted to raise. So he basically threw open the preliminary injunction briefing and asked for even more briefs beyond the first set that he received in the early part of May. So Friday night, both Kalshi and the state of Maryland filed supplemental briefs late Friday night within minutes of one another. And I was speculating at the time that nobody wanted to file too early, because if you file too early, the other party could take a quick peek and then maybe change their work and submit later. So they must have reached some kind of an agreement that, okay, we're both going to file at 7 o'clock within 1 minute of each other. And that's pretty much how it worked out. And, Kalshi's position on the issue of judicial estoppel is that whatever they said in the DC Circuit and the DC District Court on congressional control contracts was not the issue in play in that case. That case simply involved whether political event contracts fell within the special rules category for gaming, and that even though Kalshi had said sports betting is not something that Congress wanted on derivatives markets, that wasn't the issue in that case. The issue in the case was somewhat related, but the result reached by the district court in concluding that Kalshi's political event contracts fell outside the gaming categorization, that doesn't mean that Kalshi should be stopped from arguing something else about sports betting in the current case, because the first case was about the issue of political event contracts. It wasn't about whether sports betting or sports event contracts should be allowed. And that's a very crucial distinction. And, I'm on both sides. I can see both arguments here, that it is a judicial estoppel. And at worst, or at best, even if it's not a judicial estoppel, it's certainly a statement that's inconsistent with Kalshi's present position. So how the court reacts to that, and whether the court treats that as an estoppel or some negative inference to be drawn to deny preliminary injunctive relief to Kalshi, remains to be seen. And we're not going to get an answer, I would suspect, until the middle of July, because we have even more briefs that have to be filed. The response briefs to the first round of supplemental briefs are due on July 25th. And there's still an opportunity for maybe the court to have yet another hearing or to require more briefs. There could always be a wild card here, but I think this is on track to be resolved by the court by the middle of July. And judicial estoppel isn't the only factor he's considering. He's also weighing whether Congress truly intended to allow sports event or prediction markets through the Commodities Exchange Act's grant of exclusive jurisdiction to the CFTC to regulate swaps. So there are a lot of issues, and which is one of the reasons why the court asked the parties to brief anything that they wanted to. And that's why he gave them 30 pages. So there's a lot of issues that remain in play, and we'll have to wait another month before seeing how the court's going to rule.
What did the state of Maryland file on Friday night?
The counter argument that it is in fact a judicial estoppel.
Okay, so it was all focused on the judicial estoppel issue.
Predominantly, but the state of Maryland also tried to firm up its preemption argument that Congress could not have intended to allow event contracts to be governed exclusively on CFTC markets. So that was one other issue that the state of Maryland raised, and they also tried to bolster their Rule 40.11a1 argument, which has come up repeatedly, not just at conferences, but in some of the court cases, as to whether Rule 40.11a1, which sets forth a categorical prohibition on gaming contracts, to what extent that rule plays some kind of a role in determining the outcome of Kalshi's motion. Kalshi's argument is, well, if it's a CFTC rule, no matter what it says, that's the CFTC's to enforce. It's not for Maryland to enforce, and it's not for the federal courts to enforce. If anything, that reaffirms the CFTC's exclusive jurisdiction. And then the state of Maryland is arguing in response to that, well, if there's a categorical prohibition against any event contract that involves gaming, well, then the CFTC is without any jurisdiction, because these kinds of contracts aren't allowed by the CFTC's own regulation. And it's beyond the purview or beyond the jurisdiction of the CFTC to even allow it or to consider it, because they made the public interest determination 14 years ago when the CFTC unanimously adopted Rule 40.11a1. So from Kalshi's lens, the public interest analysis was done in 2011. From the Maryland's lens, that was done 14 years ago. From Kalshi's perspective, each contract submission requires an independent two-step analysis, which includes A, whether it involves one of the enumerated categories such as gaming, and two, whether this contract would be contrary to the public interest. So Maryland and Kalshi have diametrically opposite views on how to interpret Rule 40.11a1 and what role, if any, it should play in dictating the outcome of this case.
Yeah, we're going to keep watching those Maryland supplemental briefs coming in over the next week and a half or so, I believe is the deadline.
Yeah, I mean, this is important stuff. I mean, to have a discussion about briefing deadlines and court filings, it may sound like dry and very technical, but this is the third case and the third ruling, and Kalshi has a two-court winning streak. Nevada was the first decision that went in its favor, and then New Jersey largely adopted the Nevada court's reasoning, and so Maryland represents a potential, I guess, inflection point or a potential, departure from how some of the earlier courts ruled, because Judge Abelson raised a number of questions. He seemed quite cynical about Kalshi's change in position from one case to the next, and raised a number of other issues. So the role of the supplemental brief, this is an opportunity for the state of Maryland to really firm up some of the vulnerabilities in Kalshi's legal position, but at the same time, maybe the judge did Kalshi a huge favor. Whereas instead of ruling on the basis of the oral argument, where he was very cynical and skeptical about some of the positions Kalshi has taken, he's given them a second chance to basically rescue victory from the jaws of defeat. So this one could go either way, but this particular judge is very focused on some of the vulnerabilities in Kalshi's argument, but at the same time, he's given them a chance. And yeah, I guess it remains to be seen, but the outcome here is pivotal, because if Kalshi wins, some of the other states that are looking at this are going to see 3 court cases, 3 victories for Kalshi. It could disincentivize some of the state governments to, to take any kind of an enforcement action or any kind of a threatened enforcement action against Kalshi. It could actually have the effect of, could have a chilling effect on how states approach Kalshi in the future. By contrast, a state victory in the Maryland case could potentially open the door to more states deciding to, take a tougher stance against Kalshi. So this one's pivotal. The third case, third game in a 3-game series.
Yeah, let's catch up with the Third Circuit. That was so punny. Kalshi asked for a 29-day delay in the New Jersey case?
It's an expedited appeal already. New Jersey has argued to the court that they're going to be irreparably harmed by having all this delay in their ability to enforce their state gambling laws against Kalshi. So the Third Circuit U.S. Court of Appeals agreed to an expedited appeal. The first brief was filed last week on July, I believe it was June 10th. And Kalshi has responded to that initial filing by asking for a 22-day delay on an expedited appeal, essentially pushing back their deadline for responding to the opening brief from, I think it would be July 10th until July 31st, a 21 or 22-day swing. And the state of New Jersey has been somewhat generous in trying to meet Kalshi more than halfway. And instead of opposing Kalshi's request, New Jersey has told the U.S. Court of Appeals, we're going to agree to 14 days. Not 22 days. And the reason why Kalshi is seeking this delay is that the same set of lawyers are working on all the other Kalshi cases. They're working in Maryland. The case is ongoing in Nevada. And this is the Milbank law firm. It's the same group of 4 lawyers who are litigating each one of these cases. And there's a lot going on in these parallel proceedings. I mean, there's supplemental briefing in Maryland. There's discovery that's taking place in Nevada. There's an appeal in New Jersey, and the same group of lawyers are handling 2 other cases that are falling within this time window. So one of the common grounds for seeking an extension of time that I know that I've mastered throughout my career as an appellate lawyer is you work the calendar. And as an appellate lawyer, you generally have, even in trial court litigation, the lawyers have some degree of flexibility in seeking additional time to respond to court filings, response deadlines, whether it be summary judgment motions or on appeal. You get a couple of cracks at it before the court's going to say no mas, no mas. And I think the court will give Kalshi an extension. The question is whether it's going to be 14 days or 22 days. I mean, if I'm going to play cynic here, Milbank is a firm with over 900 lawyers, and the press of other litigation involving the same issues in 2 other federal courts. I don't know if that merits a 3-week delay in an appeal that's already been expedited and the court has set very firm deadlines on. So I could see maybe 14 days or perhaps even less. They will get some time. They just may not get the full allotment of time that they're seeking. I mean, come on, 900 lawyers. They're going to need 3 more weeks. They're going to need the entire month of July and the second half of June just to write a response brief. Seems a bit much to me.
Yeah, I can see how that might push the judge the wrong way, but it could go the other way too.
It will be granted to some extent. It's not completely unreasonable. It's just the amount of time seems a bit excessive. They'll get something. They just may not get the whole thing. And the reason why that's important is that, the Third Circuit case is potentially the first one that will have an appeals court ruling. And under the current time frame with the current scheduling, we could have gotten a Third Circuit decision on whether the preliminary injunction was properly entered, maybe as early as, around Labor Day, before Labor Day, shortly after Labor Day. And now this new request, kind of kicks the can down the road, by at least 3 weeks, but now puts it potentially into October, later this fall. But it will be a somewhat expedited decision. That's why the request for so much time seems somewhat surprising in the context of an expedited case.
Well, let's talk about some of those other cases that Kalshi has to face now. So Kalshi, Susquehanna, their market maker, and Robinhood have all received Well, they've all received paperwork from South Carolina, Ohio, Illinois, Kentucky, and Massachusetts, if I have my list right. What happened there? It looks like the states don't feel deterred right now.
We got 5 cases. We got South Carolina, we got Kentucky, Illinois, Ohio, and Massachusetts. I might have said the same state twice, but I think I said 5 different ones.
That sounded like 5 different ones to me.
Okay, so Kalshi was sued alongside Robinhood, Webull, and importantly, this is the really interesting angle here, Susquehanna International Group, the market maker, the primary market maker for Kalshi. I mean, you've studied this industry. Market makers play a very important role in providing liquidity on these Kalshi contracts. And I think the role that Susquehanna is playing is now starting to increasingly come into light. And this lawsuit basically places a bullseye on the process, or at least the role of market makers. Are they acting like a sports book? If to the extent Kalshi involves gambling under state law, so too would the role played by Susquehanna. So, I mean, what do you think about the possibility of Susquehanna being dragged into this?
I mean, it's an enormous power player. I believe they also work with Sportrade. So they also do some market making with, within the gambling industry. So it'd be interesting to see them, draw a line between, work they do with, Sportrade in the gambling industry and Kalshi in the finance industry. And, whether that role is meaningfully different or whether, it matters, in regards to how Kalshi offers its event contracts.
Yeah, I mean, the really interesting aspect of this case is it's not on all fours with the kinds of cases that Kalshi has filed against the states. Kalshi has sued Nevada, Maryland, New Jersey under a very narrow constitutional theory that whatever the states are trying to do is preempted by the Commodity Exchange Act. These lawsuits are against Kalshi, Susquehanna, and Robinhood are being advanced under state law. And this is not necessarily the same preemption battle that Kalshi is fighting with the states. So Kalshi may have a somewhat difficult time getting these cases removed from state court to federal court because the analytical framework for determining whether complete preemption applies, some of the legal doctrines are not the same as what is being invoked in the federal cases against the state governments. And this is really important because Kalshi is being sued under the state law statute of Anne, which is it goes all the way back to the English common law. Many states have these loss recovery statutes that entitle individuals to bring lawsuits seeking the recovery of quote unquote gambling losses from the winner of the gambling game. And what is characteristic of Kalshi's event contracts? The winner isn't Kalshi. The winner, to the extent this is even gambling, and that's going to be an issue that could be settled, or at least in these 5 cases. But who's the winner of the bet? Is it Kalshi, or is it the counterparty on the other side of the bet, and who's liable for paying these damages? So the cases raise some really interesting analytical issues. One, over whether this is removable to federal court, even though it involves state law gambling claims. And how do you assign damages if Kalshi is agnostic as to the outcome of the event contract?
Yeah, that's going to be a really fascinating fight to see play out. Let's bring in there was some reporting about a potential partnership between FanDuel and Kalshi. At the same time they're facing these now state gaming lawsuits. What might FanDuel get out of this partnership, and why might they not want to enter that partnership right now if it's a serious discussion?
I mean, who wouldn't want to be part of this DCM marketplace if this is going to be the sort of the lay of the land for the duration of the Trump administration, if not longer? If you're DraftKings, if you're FanDuel, if you're BetMGM, you're Caesars, you're any of these other major online sports betting companies, you at least need to keep your eye on the prospect of if you can't beat them, join them. And I think discussions like this, to the extent they happen, are usually behind the scenes. I would think every every major OSB operator has a game plan in place for the prediction markets, but they're not all so public about it. And one of the downsides to being so public about it is it's a difficult or delicate balancing act because DraftKings, FanDuel, and all these other companies have relationships with the state regulators, who basically are their partners, who are waged in battle against Kalshi. And then these same companies are trying to court the Native American tribes, who believe that the prediction markets intrude upon tribal sovereignty. So there's the optics of being seen abandoning state by state regulation. It potentially could put these companies sideways with their Native American would-be partners, and sideways with some of the state regulators who are on the front lines battling Kalshi. So there's a lot of hesitancy about going in with both feet first because of the uncertainty around the legal landscape on prediction markets. Right now, it's the question of their legality has not been conclusively established by the federal courts. Kalshi is winning these early stage lawsuits on preemption grounds. Really, that the issue of legality and whether these are allowable is the CFTC's call, and the CFTC's alone to make. But the issue of ultimate legality may not be settled for a few more years, and that could give some of the online sports betting companies pause about trying to operate parallel as a DCM or as a partner of a DCM. So they got to tread a little bit carefully, given the uncertainty surrounding the legal landscape. But at the same time, these markets offer 50 state access, no license fees other than becoming approved as a DCM, no state excise taxes, no restrictions on advertising. You're basically operating in a permissionless, almost regulation-free environment, having 50 state market access to contract or traders 18 years of age and older, whereas in state-regulated sports betting, the minimum age to gamble is going to be 21. So it's a question of market access and opening up the remainder of the country, which is why any company would want to be interested in a partnership with Kalshi or potentially becoming a DCM itself.
Well, we'll get them into California and Texas, the last two, I think, big market holdouts in terms of online sports betting.
You could also include Florida in that, because Florida is a closed market except to the Seminole Tribe of Florida's Hard Rock Digital Sportsbook. So when you look at the three largest states, that's 30% of the U.S. population, that most of them don't have access to any digital sports books. And in Florida, they only have access to one. And then you add Georgia, Minnesota, a few other, the big holdouts, and you're probably pushing closer to 35-40% of the U.S. population that does not have access to legal online sports betting in the United States. So the opportunity here is an enormous one for companies like FanDuel, DraftKings, BetMGM, Caesars, and the like. The question is, do you have a game plan? How do you execute on the game plan? Do you apply to become a DCM now, or do you try to acquire a company that has a DCM, or just acquire their DCM? I mean, there are many paths to entry here, and I'm 100% certain they all have a backup plan, or at least have made some kind of inquiries and thought about how they want to pursue this. Just very little of it has been made public so far, with the exception of this news item from Front Office Sports, and then several months ago, DraftKings Predict made a filing with the National Futures Association, which they later withdrew. So it remains a big mystery as to how these companies are going to approach sports prediction markets. But we'll begin to hear more of these stories and more of these news items, because it can't be ignored. It's getting too big.
Well, as it grows, it's running into some serious issues with the tribal groups. So let's dive into this this tribal group's amicus brief getting set to be filed on Tuesday. There's a draft opinion circulating around right now. There are some new issues that are being raised that are very different from the ones Kalshi is facing in its current, even in the new lawsuits from states. So tell us a little bit about that. I mean, what are some of these new arguments that are being put forward?
I think, Chris, the backdrop of all this is that the tribes tried to have dialogue with the CFTC through acting chairman or chairwoman Caroline D. Pham. I don't know why they refer to her as chairman. It's not gender appropriate, but that's how they refer to her. And she had a conference call with a group of tribes and their representatives, and she said, "We're not going to make any decisions on this." And she basically didn't close the door, but didn't leave the door open to having these event contracts rejected by the CFTC. So from the agency standpoint, what's happening now is going to continue to happen. And then Brian Quintenz, a week later, during his confirmation hearing, is basically telling the tribes that they've got to go to Congress if they want to change, change the rules, change the law. And the tribe's position is that the law already grants them exclusivity over sports betting and gaming on their Indian lands. And the contracts that Kalshi is offering to anyone who has a cell phone that's on an Indian reservation is potentially entering into those event contracts in violation of tribal compacts, which guarantee the tribes exclusivity over gaming on their own lands, as well as statewide exclusivity over new forms of gaming. So, for example, in California, you could have a situation where what Kalshi is doing is allowing people to enter into contracts, buy and sell contracts within the parameters of Indian reservations, but even going beyond that, throughout the rest of California, these compacts often give the tribes exclusivity over all forms of gaming, Class 3 gaming in the state, other than, let's say, the card rooms and some thoroughbred or horse racing, which is also considered a Class 3 form of gaming. So the arguments that the Native American tribes are raising in the amicus brief is bookended around the Indian Gaming Regulatory Act. And I'll just read you a couple of quotes. I might as well use precise language here that, according to this tribal brief, Kalshi's unlawful and unfair entrance into the gaming market has adversely impacted tribal gaming revenue and the benefit of tribes, plural, bargain for compacts. In addition, by offering its so-called sports event contracts under the guise of commodity trading pursuant to the Commodity Exchange Act, Kalshi impedes tribes' inherent sovereign right to regulate gaming activity on Indian lands. So the essence of the IGRA argument is that these contracts are available on Indian lands in violation of IGRA-approved contracts, and therefore violates the Federal Indian Gaming Regulatory Act. So the contracts by themselves violate federal law to the extent that they are available on Indian lands, and Kalshi does not geofence their traders based on whether it's on reservation or off reservation. And according to Kalshi, and some of the affidavits and declarations that they have submitted in the federal court cases, they don't geolocate, and it would cost them millions of dollars, tens of millions of dollars, if they were forced to utilize sophisticated geolocation technology. And for that reason, the threats being made against them by state governments would cause them irreparable harm by requiring them to have to geolocate customers on a state-by-state basis, which they're currently not doing.
Well, this is interesting because, in these new tribal amicus briefs, in this new one, Kalshi is running afoul of federal law now, as alleged in this brief, that seems like a new angle on Kalshi's legal troubles as well.
Well, it was really important, Chris, for the tribes to weigh in here, and I'll tell you why, because the states are not well positioned to advance an IGRA argument. I mean, there are no tribes in New Jersey. There are no tribes in Maryland. I don't know if there are any tribes in Nevada. So the first three cases that Kalshi has filed against state governments, those are not tribal-centric states. And while each one of the state attorney general's offices in those lawsuits have grouped IGRA along with the Wire Act and PASPA as providing sort of a federal policy disfavoring sports gambling, nobody in any of those cases has threaded the needle exactly on using on articulating why event contracts may violate IGRA. I think IGRA was used as part of a suite of federal laws to argue that there's no federal preemption, but the importance of the tribes getting involved here is that IGRA is their forte. I mean, the names on the briefs. I mean, I'm looking at the brief right now. This is filed by a quartet of lawyers: Brian Newland, the former, Assistant Secretary of the Department of the Interior under the Biden administration; Joseph Webster, who represented the Seminole tribe in the West Flagler case; Scott Crowell, one of the leading tribal gaming lawyers in the United States; and Michael Honig from San Manuel Nation, who is the former general counsel of the National Indian Gaming Commission. So you basically put together an all-star team of tribal gaming attorneys, properly framing the IGRA argument and wanting their voice to be heard, because I don't believe that the IGRA arguments have been sufficiently or meaningfully framed in the context of these various litigations. And in the Third Circuit, once you get to an appeal, that's when you start seeing amicus curiae briefs. You can file them at the district court, but they're more typical when cases go up the judicial ladder and are argued before the U.S. Courts of Appeal and the U.S. Supreme Court. And the deadline for filing an amicus brief is Tuesday, but the draft of this brief was circulated a few days ago through Victor Roach's Gaming News Digest, which is a daily email blast that he sends around the industry. And the brief was available on that daily news digest with a call to arms, looking for other Indian tribes to sign on to the brief. Right now, the only named amicus is the Indian Gaming Association. But between now and Tuesday, when they file, you might end up seeing 10 or more Indian tribes and maybe even some other tribal associations joining forces with the IGA, the Indian Gaming Association, to give the brief even more heft as representing tribes across the country, and not just simply either in California or one particular jurisdiction. This is going to be sort of a national voice being brought to bear in the Third Circuit U.S. Court of Appeals. And I think this is not the last time we're going to see the tribes weigh in an amicus curiae capacity. I wouldn't put it beyond the realm of possibility that they wouldn't file in Maryland. I think there's a window of opportunity between now and when the reply briefs are filed in Maryland on June 25th on the supplemental briefs. There could be a window even within that time frame for the same tribal groups to file an amicus curiae brief in Maryland, or at least seek the court's permission to file one. Because if they're filing one in the Third Circuit on Tuesday, they could file the same brief in Maryland on Wednesday. And I think it's important. The most important battleground right now, in my opinion, is Maryland, because Judge Abelson has raised some very important points and has been skeptical of some of the arguments raised by Kalshi before the Maryland federal court. So if you're looking to get W's, or you're looking to stunt the momentum of Kalshi, the most immediate point of entry, the one that will have the greatest impact at the quickest possible, at the soonest possible time, is the Maryland case, because the Maryland case will be decided on the district court level before the Third Circuit renders its ruling. So I could see the same group of tribes trying to pick their spots in various jurisdictions: Third Circuit, New Jersey, maybe even Nevada. And then when that case goes to the Ninth Circuit. So this is the beginning of what is going to be a very active period of time in which the tribal stakeholders are heard on this issue in the federal courts. And it makes sense for them to pursue relief in the federal courts, because they're not going to get relief from the federal agency. And I think there's a much more level playing field when you approach the Article 3 judges that comprise the federal judiciary. They're not appointed only by Donald Trump. Some of them are appointed by Democratic presidents, other Republican presidents. I think they're going to get a fairer shake if they pursue the court angle.
Yeah, that'll be a hugely important angle to watch in these lawsuits.
Yeah, and the tribes have also, in my opinion, written the most effective brief in all the cases. So I think this is a group to watch very carefully. They know how to write a good brief, and for my money and in my opinion, this is the best brief that's been filed in any of the three cases. They not only tackle IGRA, but I think they do a very effective job in skillfully articulating the Rule 40.11A1 argument, which could be a jurisdictional bar to the CFTC having any role in approving event contracts. So this is an important battleground. Third Circuit and Maryland, and the tribes have come to the rescue of some of these states, and it's going to be pretty interesting to see how the courts receive some of these arguments from the Native American tribes. They're going to be taken seriously because they are one of the most affected stakeholders in the gaming industry. So it makes sense for them to weigh in as an amicus curiae.
Mm-hmm. Yeah, absolutely. We're absolutely looking forward to seeing how these cases shake out, and especially seeing how Maryland is decided. But we have to leave it there. As always, if you like what you've heard today, like and subscribe at our YouTube channel. Check out our reporting at predictionnews.com, and we'll touch base again and release another episode when there's more to talk about, which I'm sure will be quite soon.
In like 2 more days. One day. I mean,
sure. I mean, 12 hours. Who knows, right?
Yeah, filing deadline for the Third Circuit on amicus curiae is going to be Tuesday. There should be more organizations that file amicus briefs. I would expect that we're going to hear from the Casino Association of New Jersey, potentially others, and maybe some wild cards in the Maryland lawsuit.
Yeah, that'll be fascinating. Well, Dan, thanks again for joining us tonight. I know it's late. Thank you.